trenches water as a constitutional right by establishing a right to, I quote, Honorable Speaker, reasonable standards of sanitation and, I quote, clean and safe water in adequate quantities. The Constitution under Article 21, Honorable Speaker, further places an obligation on the government to take steps to progressively realize this right. My Speaker, notably, Kenya is classified as one of the water-scarce countries. This means that a lot of effort is required in terms of funding and relevant resources to ensure quality and adequate water is supplied to the 50 million citizens. Thus, the need for public-private partnership as a means to drive economic development and infrastructure projects. Honorable Speaker, further, this will significantly increase the framework for the implementation of PPP projects in Kenya, which outlines the processes for initiating, evaluating, and implementing PPP projects, as well as the
majority leader, because as a departmental committee of Blue Economy and Water and Irrigation, we did invite the Cabinet Secretary, that's the Minister of Water, so that we could deliberate on the issues pertaining the PPP, that on water, the issue to do with bulk water, who is supposed to be regarded as a bulk water supplier, which Honorable Speaker, as a committee, we did reject all the other clauses which the Senator had recommended, apart from clause 9 and 10. The reason for our rejection to allow the PPP to move on. So as a committee, we felt that all the other clauses apart from 9 and 10 was agreeable. I therefore second.
Other members on their feet, take your seats. Mama Kericho, take the nearest seat. Honorable members, I now propose the question, which is that the Senate amendments to the Water Amendment Bill, National Assembly Bill number 33 of 2023, be now considered. We put the question and go to order number 12. We will return to order number 11.
Order number 12, motion. Consideration of the Public Finance Management Kenya
publishing a corrigenda to correct the minor errors appearing in regulations 11 and 16. Honorable members, I hear you that I should put the question. Honorable members, I now put the question that this House adopts the report of the Committee on Delegated Legislation on its consideration of the Public Finance Management Kenya Millennium Development Fund Regulations 2024, laid on the table of this House on Tuesday, 23rd April 2024, and pursuant to the provisions of Section 24(4) of the Public Finance Management Act 2012, approves the Public Finance Management Kenya Millennium Development Fund Regulations 2024 of legal notice number 51 of 2024, subject to publishing a corrigenda to correct the minor errors appearing in regulations 11 and 16. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. You know what? Let Milema come and sit on the Next order.
Order number 11, Committee of the Whole House.
Order. Honorable Soro, assume your seat. Okay. Am I resume our seats? Hapo Wanjiru. Honorable members, we are now in the Committee of the Whole House, and members, as you can see in your order paper, the first, we'll start with the second item there, the National Land Commission Amendment Bill, National Assembly Bill number 43 of 2023. And Honorable Bayer Owen, I think, is moved the bill. And without hesitation, I take it you're still consulting. Have you finished your consultations? Thank you so much. So we'll start with the National Land Commission Amendment Bill. And I propose the question.
Clause 2.
I propose the question that clause 2 be amended as proposed. There are two proposals for amendments there by the Lands Committee, and I would invite I propose the question that clause 2 be part of the bill. Chairman of the Lands Committee.
Thank you, Mr. Chair. Mr. Chair, I move that clause 2 be amended as contained in the order paper. The reason or justification for that amendment is that clause 2 of the bill proposes to amend section 14 of the National Land Commission Act through deletions and subsection 2 and 9. However, section 14 of the Act is couched as a transition provision that was to expire 5 years following its enactment, hence the provisions of subsection 1. The committee proposes to substitute clause 2 of the bill to align with Article 68 CV that does not anticipate a time limit where the National Land Commission exercises the function of reviewing grants and disposition. I move.
Thank you. I now propose the question that clause 2 be amended as proposed by the chair of the Lands Committee. The Honorable Wundo, go ahead.
Chair, thank you for giving me this opportunity. Probably the chair could also give a little bit further clarifications in terms of the review of the grants and disposition. Now that we are removing any time limit, would probably be interested to know if the disposition and the grant has actually been done by the National Land Commission itself during this currency. How do we approach such kind of a situation, or does the matter now lie directly to the High Court instead of the National Land Commission? So that we understand clearly what's the import of the amendment, so that we don't get mixed up into some kind of a situation where the self-review what I've already done. Because currently, since the new constitution came into place, CNLC came into place, they'll be the one in charge of grants of public land to individuals or any other public entities. So we need to know exactly what's the cut-off date in respect of this particular clause. Thank you, Chair.
Chair.
Thank you, Mr. Chairman. Chairman, what we have is amendments which were moved during the second reading, and it was the feeling of the entire House that the time limit which had been set, the 5-year term limit, was a bit inhibiting to the National Land Commission. That's why we came up with these amendments, just to clean and make sure that we are able to align that particular amendments which was proposed, so that it's in line with the Constitution, so that there are no contradictions. So in essence, what we are trying to do is just to clean up and just make sure that the article, this clause number 2, is very clear.
Thank you. Members, if there's no further intervention on that, I wish to... Yes. What's out of order? Did you say out of order? What is out of order?
Out of order. I wanted to make a contribution. I'm sorry, Honorable Chair.
Oh, you want to contribute? Go ahead.
So could the chair further clarify what the new term is? You have explained everything very well. You wanted to align it with blah, 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 blah. Please just tell the House what then the new term is as per your proposal. Thank you, Chair.
Go ahead, Chair. Just use the one next to you.
I think I was very clear, Chair, that there's no time limit.
Oh, so it's
just
been left
endless.
open.
Yeah.
Okay, thank you. Members, if there's no intervention on that again, I wish to then go ahead and propose that there's a further amendment by the Honorable Owen Bayer to clause 2, and we invite the Honorable Owen Bayer to move his amendment.
Now, Honorable Speaker, I would like to move a further amendment in the same, that we replace the word all after the word review in section 14 of the Principal Act, so that we remove the word all and substitute it with the word any, because it says review all grants. Now, all would mean that the Commission needs to do all grants that had been issued. But then when we substitute the word any, it is any that is presented to the committee. And therefore, I would make that further amendment on the same, on that clause, and subsection 1. Thank you, Honorable Speaker.
Thank you. Well, members, I therefore propose that clause 2 be further amended as proposed by the Honorable Owen Bayer. Yes, Honorable Wundo.
Chair, it's a progressive amendment, and we need to support it. But again, I still go back to the gist of the amendments in totality. I'm not so sure whether the National Land Commission has reported that it was unable to complete the review process as contemplated in the original act, but now that's water under the bridge. The only point that he's trying to raise, which seems to be fairly a good idea, but the point of question is, what happens to that person who does not know, the indolent, iniquity, where we don't wake up a sleeping dog? But what happens, because it says in say any, but the amendment by the committee was that all. So it meant that all the grants and the disposition that have been made will be reviewed. And again, here we don't have any time frame. They can take 100 years, they can 300 years. We need a bit more clarity. See, that's why we are saying we need more clarity, Chair. Whether we are saying any, but after how long? I have been given a title, nobody objected. 5 years, 10 years down the line, I have invested, I have improved the property, and then you come and make a claim. Is it being limited by statute of limitation? You lawyers, you know better, of 12 years, or does it exclude that limitation of action so that we leave it open completely throughout? We need that clarity, Chair. See, as I always say, when we are making laws, we must be sticklers to the details so that we avoid a situation where there is too much room to interpret the law as there are many lawyers as in the House. Thank you, Chair.
Thank you. Honorable Baya.
Honorable Speaker, I follow what the Honorable Oundo, a good professor of planning, that yes, there has been those questions. But I think the answer to those questions, Honorable Speaker, lies in the Constitution. I would invite you, Honorable Speaker, that you look at Honorable Chair, that you look at what Article 67E of the Constitution provides, which provides that to initiate investigations on its own initiative or on a complaint into present or historical land injustices. Now, if you look at the word present cannot be limited to a certain framework of time. And therefore, to put a limitation on the Constitution through a statute by saying that we only limit it to 5 years or 10 years or 20 years is defeating the letter and spirit of the Constitution. And therefore, I would like to invite Honorable Oundo to look at it from the prism of the Constitution and therefore agree that we need to do away with the time frame because the Constitution did not envisage a time frame for historical land injustices that are present and in the past. I thank you.
Thank you.
Chair.
Thank you, members. I now put the question that close.
Though the Honorable Owen has quoted the Constitution, but I thought, because I was reading the bill after it had been called out to order, that we check it. And I noticed that there must have been a reason why there was need to have a time limit. Because, yes, there are land injustices that are there. So I took my time and read. But some of those land injustices are even broad and deeply they are more deep than even the level at which we may be imagining. Such that when we open a Pandora of the entire review, even to that level, particular age of time, which we imagine that this is the type, for instance, I'm a historian, and I know there was land alienation. But it gives space to even those who earlier than land alienation may also come up and claim a review. I would want to hear Honorable Owen Bayer's views on that. Thank you.
But that's not Owen Bayer's amendment, but let's hear what he says.
Honorable Chair, if you read the entirety of Section 14 of the law, it actually tells you what kind of claims will be put before the Commission. And if Honorable, the good teacher and Omboko has not read you cannot really look at a law and look at just one subsection 1 only. If you go into the depth of that, you'll be able to understand the spirit and letter of it. So I would request you to look at what is historical and what is historical land injustice. It is enumerated down there further so that you don't just wake up and take any claim there. It has to meet certain parameters and certain standards. And therefore, that guards into how many years we can go down the line. I thank you, Chair.
Very well. This now has to go to the vote, and therefore put the question that clause 2, as amended and further amended, be part of the bill. Will as many of that opinion say aye? Will as many of that opinion say nay? The ayes have it.
Clause 3.
I propose the question that clause 3 be part of the bill. Chairperson?
Thank you, Mr. Chair. I move that clause 3 be amended as contained in the order paper. And the justification is that clause 3 of the bill proposes to amend section 15 of the National Land Commission Act through deletion under subsection 3 and 11. However, section 15 of the Act is called as a transition provision that was to expire after 5 years following its enactment. Hence, the provisions of subsection 1, the committee proposes to substitute clause 2 of the bill to align with Article 67(2)(5) that does not anticipate a time limit where the National Land Commission exercises the function of initiating, receiving, admitting, and investigating a complaint on present historical land injustices. Thank you.
Thank you. All members, I propose the question that clause 3 be amended as proposed by the Honorable Namoko. Is Honorable Undo?
Chair, again, as it might look very plausible, it must be look nice to talk to the gallery, but here we are opening a very, very, very dangerous situation. In the initial bill, the Parent Principal Act, Chair, it talks about the provision of this section shall stand repealed within 10 years, meaning that within 10 years, if you indeed had an issue about any historical injustice, you must have petitioned National Land Commission, you have petitioned the courts, you must have exhausted all avenues. Indeed, the Constitution has been with us for over 10 years. National Land Commission has been with us for all that years. I know this was an amendment brought by Honorable Owen Bayer, and I can understand the historical aspect of it. The absentee landlords, whatever they are. But honestly speaking, Honorable Chair, we must bring some issues to a closure. We must bring some issues to a closure. We can't live in eternity with a problem. We must come at a time, we must bring a matter to a closure. Even when you have a dispute with your neighbor, common sense and fairness requires that we must bring the matter to a closure. We cannot just leave it open forever, because then perpetually the National Land Commission will do nothing else, but it's going to be saddled with boundless and endless complaints of historical land injustice. We have the issues that when we did the survey, the general surveys many years back, the land boundaries were never precise, were never fixed, were never exact. And that's why even the Constitution itself, Honorable Chair, talks about dispute, a traditional dispute resolution mechanism. Yet, this amendment seems to be oblivious to that provisions in the Constitution. As much as it is good for his constituency, the coastal strip, the Mazurui, the ward, whichever way, finally, Honorable Chair, the Masais are going to come and claim Nairobi because it's a historical land injustice. But Ashina is here, and this guy is arming himself to do the same.
The point is
suggest, yes, the 10 years have lapsed. We could also introduce another timeline, not just leave it open forever.
Thank you.
Because then, National Land Commission...
Honorable Wundo, you've made your point.
And I can make much more points.
Order.
I was a teacher on this matter.
Order. Honorable Wundo, what you're proposing is okay, and yet you know the rules. These amendments have been here on the order paper. You'd have just put your own amendment and say, we leave it at 10. Your point is well made. Is there any other intervention? Members, Honorable Mboko, okay, go ahead.
Chair, let me just go on record. And I know you may lump me together with the Honorable Undo, but when I looked at it, and Honorable Bayer, I'll take very little time, we should have thought of an extension and not infinity of the whole thing, so that we actually can be able to conclude. I don't know what you can do from where you are, but we should not litigate on land injustices forever, but we would even extend another 10 years after which we close. Thank you, Honorable Speaker.
But where were you, members? What you do normally, order, what you do normally in these situations is approach the member concerned. He can even accept to move for you a further amendment. But be that as it may, I now put the question that clause 3 be amended as proposed. Last one of that opinion say aye. Last one of that opinion say nay. The ayes have it. Honorable members, I now put the question. This is a further amendment to clause 3 by the Honorable Bayer. The Honorable Bayer, you have a further amendment to clause 3. There's no further amendment to clause 3, right? Yes. Is there a further amendment? Which one? Why didn't you move them together? Clause 3. Chair, next time with your amendments, you move them together. You don't move them in bits. So you go ahead. Which further amendment do you have, Honorable Chair? For which clause? You just moved your amendment already.
Thank you, Honorable Chair. Honorable Chair, I move that clause 3 of the bill be deleted and substituted by the following new clause as contained actually in the order paper. Honorable Chair, while we are doing this, is that the committee proposes to amend the bill by inserting a new clause, number 4, to address an emerging practice.
Order. The Honorable Nyamoko, what we've been discussing all this period was your amendment.
It's a new clause. Actually, it's a new clause.
So you resume your seat.
All right. So while we are doing this,
order. Resume your seat. We will have time for that new clause coming up. The further amendment is by the Honorable Toroi Teach.
Yes, Honorable Chair, I have a proposed further amendment as is contained in the notice. Chair, I wish to propose an amendment under the new clause 3 to that the proposed new clause 3 of the bill be further amended in section 15 of the Principal Act by inserting the following new subsections immediately after subsection 13. Honorable Chair, 14 to propose that the Commission shall complete an investigation under subsection 10 within 6 months. 14.2, Honorable Chair, that the Commission may submit to the National Assembly a request to extend time for a period that does not exceed 6 months where the Commission does not complete an investigation under paragraph 1. And 14.3, that the National Assembly may only approve the request under subsection 2 once. Honorable Speaker, under section 15, that the Commission shall, in consultation with the Cabinet Secretary, publish regulations to operationalize this section within 6 months of enacting this Act. Honorable Chair, the purpose of this amendment is so that when a person has a claim of an historical land injustice, then that particular claim has a definite time in which that particular investigation or a hearing is conducted. Honorable Speaker, I have proposed that the same should be heard within a period of 6 months, and if it is not completed, then thereafter, that the Commission shall seek further extension of time within 6 months, which comes to 1 year, under which an historical land claim can be heard and determined and disposed by the National Land Commission. So, Honorable Chair, the purpose is to limit the hearing of a historical land claim following an historical land injustice within a period of six months.
Thank you. All members, I propose the question that clause 3 be further amended as proposed by the Honorable Toritich. Yes, the Honorable Member for Mgwen.
Thank you, Mr. Speaker. I wanted to just propose the amendment, to support the amendment made by the Honorable Member for Marakwet West, Honorable Timothy Kipchumba, on the same, that we have a definite time, and also the 6 months he mentioned, an appeal for extension of time for another 6 months. I support this, Mr. Speaker, because the county that I come from, Nandi County, we've had a lot of historical land injustices. And up to date, several years back, have passed, yet we've never had a solution on the same. So I want to support the same amendment that we shorten that time period to 6 months, and someone can also apply for an extension of another 6 months. I support. Thank you.
Thank you. Honorable Madenge.
Thank you, Honorable Speaker. I stand to support that amendment. Honorable Speaker, when you look at the issue of historical land injustices, 60 years after independence, it is sad that these issues remain unresolved. In my own constituency of Nyeri, the issue of the people who are left in the colonial villages, despite being Mau Mau freedom fighters fighting for the land, has remained unresolved today. And therefore, Honorable Speaker, as a matter of expediting justice on historical land injustices, it is important that we put a cap on the duration within which NLC must resolve those issues once any Kenyan has lodged a case. I support, Honorable Speaker. Thank you.
Yes, Honorable Wundo.
Chair, probably I come from a school of thought that everything must have an end point. It can't just be an open check, an endless process where we litigate non-stop. Even election petitions, emotive as they are, there are timelines. Even the presidential one, of such public interest, there's a timeline. I sincerely support the amendment moved by the MP for Marakwet West, that indeed, once the matter is seized by the National Land Commission, they must be required by law to conclude it within a certain period of time. However complex it is,
thank you.
There can be something so complex that it cannot be resolved in 1 year. Because this is a matter of record, there are witnesses, if they are dead witness, they are dead witness. There's nothing you can do. You can't exhume the bodies, give them life to come and give evidence. They are dead. Within 1 year, you must have resolved the matter. We also don't want to be held into circles, like the petition, the Committee of Petitions here, that has been unable to move. So we need that timelines. I sincerely support and urge the committee and the majority side to accept that amendment so that we are able to put a cap.
Thank you, Honorable Wundo. Thank you.
Thank you.
Honorable Wangwe. Behind him. No, use this one that's already up.
Thank you, Chair. Chair, I want to agree and support the Honorable Member for Marakwet that indeed timeline is very important, very, very important indeed, especially having very strong issues like these ones. But, Honorable Chair, what I'm having a reservation on is, should there be a situation where within that 1 year it cannot be concluded, what window are we likely to give to the Commission to at least extend, if at all we can consider a very unique circumstance which might arise in very many cases, that we don't lock it up so that there is no window at all to look into a matter which is very controversial or maybe which is very extraneous beyond that time. Thank you. Otherwise, I support.
It's a very valid point that is being made, Honorable Wangwe. I know of cases where when you put a timeline like this one, you put 1 year, anything done by that commission beyond that 1 year is a nullity. So the question he asks, I think, is quite valid. If you get an overzealous court, you may have done work, very hard work for 11 months and 29 days. You just need another 30 days to finish. But the court will say that anything you did beyond the 1 year provided for is nugatory and doesn't help. The Honorable Timothy, you're a lawyer yourself, you should think about what the Honorable Wangwe has raised as a point of mulling over. If there's, you want to say something on that? Okay.
Honorable Speaker, even in a court of law, litigation cannot be done in perpetuity. There must be closure to even a matter if it is before a court of law. Honorable Speaker, even in the presidential petition, we have a time limit. So, Honorable Chair, if this, we must, because, Honorable Speaker, if a matter is heard for a period of 10 years by the Commission, that in itself, Honorable Speaker, is an historical injustice. It is an injustice. So, Honorable Speaker, there must be a determinate period of time in which a matter is heard and disposed by the National Land Commission. Honorable Speaker, if you give the Commission, if you don't give the Commission a time frame in which to hear, determine, and dispose a matter that is taken before it, then, Honorable Speaker, that amounts to an injustice. Honorable Speaker, we are in a jurisdiction where we normally set timelines on matters. So, Honorable Speaker, I call upon the members of this House to pass that amendment that will set a timeline to which a matter is handled by the National Land Commission.
Thank you. Honorable Nyamai. That one worked.
Thank you very much, Chair. I would like to support this amendment by the member for Marakwet, Honorable Timothy, bearing in mind that historical injustice cases of land are cases that have taken a very long time. So, for us to have a period of 6 months and a possibility of extending for 6 months, going beyond that, Honorable Speaker, will be injustice in itself. So, I would like to support.
Thank you. Before I put the question to a decision, there is a further amendment to the amendment by the Honorable Bayer.
Just come, give the mic out. Be here.
Amenda tunayo tena. You couldn't just pass like this.
You're in the committee of the whole.
Honorable Speaker, with tremendous respect to the Honorable Member for Marakwet, is that yes, I agree we must have a timeline in principle, and I want to support that matter. But Honorable Speaker, I think we also need to be realistic to the kind of issues that get that.
Order.
Yes.
There are senior members of this House. You know why we've asked you to rise.
Honorable Speaker, I beg to move a further amendment that the proposed new clause of the bill be further amended in Section 15 of the Principal Act by inserting the following new subsections immediately after Section 13. The Commission shall complete an investigation under Section 10 within 1 year. and that the Commission shall, I would like to say, we say the Commission shall publish regulations to operationalize this section within 6 months. Now, Honorable Speaker, the import of this is that 6 months will be very short, considering the issues that are raised within a historical land injustice. And if then after 6 months we must come back to this Parliament again and seek, then there's nothing much that will be achieved. But I propose that we do 1 year with an option of seeking an extension from Parliament after 1 year. And I think this is neater. Secondly,
Honorable Bayer,
yes.
You know it's neater
Yes.
to do one thing at a time.
Yes.
The amendment you're moving is to the Honorable Timothy's amendment to sub-articles, subsections of subclause 15,
Yes.
not 14.
Correct.
So that's 15. What you are moving is to move the period of regulations from 6 months to 1 year.
1 year.
You have to clarify that so that we are not confusing with the 1 year for investigations, because you're confusing the two.
Okay. So I'm entirely in agreement, but we extend it to 1 year. And I want to ask, request the Honorable Member, Kipchumba Teretich, to second me on the same.
Thank you.
Because we're in agreement.
Thank you. I therefore propose the question. I propose a question that clause 3 be further amended as proposed by the Honorable Bayer.
Honorable Chair, I am in agreement with that further amendment to extend the period from 6 months to 1 year.
Thank you. Honorable Milemba.
Oh, it's back. It's back. So I don't need the other microphone. I support Honorable Bayer's amendment because it's giving a little bit more time, just in case the cases so said are even many. Then 1 year even gives more leverage. Because the main reason why this amendment is coming up is to actually protect those accounts which are usually guaranteed by lawyers, and therefore stop these cases from proceeding for a very long time. But 1 year should suffice for all the parties. Thank you.
Thank you. If there's no further action on that, I would therefore propose the question that clause 3 be further and further amended as proposed by the Honorable Terotich and the Honorable Bayer. Will as many other opinion say aye? Will as many other opinion say nay? Ayes have it. Members, I now put the question that clause 3 as amended be part of the bill. Will as many other opinion say aye? Will as many other opinion say nay? Ayes have it. Members, we go back to clause. It's just important to note that the proposal by the Honorable Terotich in its second part at 15 falls, and the one by Honorable Vaya then is carried. All members, I would wish just to go back to clause 2. We dealt with it earlier, to just take a vote that clause 2 as amended be part of the bill. Will as many other opinion say aye? Will as many other opinion say nay? Ayes have it.
New clauses. New clause 4.
Chairman. Chairman.
Thank you, Mr. Chairman. Mr. Chairman, I move that the bill be amended by inserting a new clause, number 4. The justification, Mr. Chair, is that the experience we've had in dealing with National Land Commission is that there are instances, and it has become a practice, where courts grant orders attaching the bank.
Honorable Nyamoko, you know this is a new clause.
Yeah, it's a new clause.
Yeah, so I want to start by saying that you're moving that it be read a second time. Then you go on to explain what you're explaining.
That?
start by saying that the new clause 4 be not read a second time. Because it's a new clause, we have to read it a second time.
That the new clause 4 be amended.
Be now read a second time.
Be now read a second time.
Correct, then go ahead.
Thank you.
Honorable Nyamoko, I want you to...
So I go ahead to give the reasons?
Yes, because we are not amending now. Remember, there's nothing you're amending now.
Okay.
Remember, you're introducing a new clause. So start by saying that you move that clause 4, new clause 4 now be read a second time, and then you now tell us what you're proposing to put in the law as a new clause.
Yeah, why we are proposing that this new clause be included is because the National Land Commission has had a lot of issues in lawyers especially going to court and attaching the accounts of the National Land Commission. This has happened in the past, and Mr. Chair, you know very well that the National Land Commission receives monies from different entities, especially acquiring entities, like the Kenya National Highways Authority, the KURA, the Ministry of Water, for onward transmission to project-affected persons. So when those guarantees are given, this money is meant for a different purpose. And that's why, based on the experience and the interaction we've had with the National Land Commission, we found it prudent for us to protect this particular account.
Thank you. Thank you. Members, I propose a question that the new clause 4 be now read a second time. Honorable Wundo.
Chair, this is very interesting. Coming on the heels of a judgment, I think, in the High Court that said that the government is not necessarily immune to recovery procedures in the event of failure to honor a judgment or a financial obligation. And I must admit, sorry, I have been aware, that's why I didn't follow the amendments. I thought it was not come soon. Would have actually separated, just like advocates do, they have a client's account, just like us estate agents also do, we have the client's account. Probably it's the client account that should have been insulated against garnishment orders or any recovery process. But now lumping all the funds, it's indeed telling the commission that you guys don't do much, you are protected, you are taken to court, you don't go to defend the court cases, you are protected. We are going to create a bit of chaos. Yes, there is a good reason for it. I can see it from far. But unless we cure by separating the two accounts, two sets of accounts, then we are not curing the problem. And again, that's the sorry I must admit. I didn't have time, and that's why we allowed this kind of amendments have gone through without tidying them up, and we are creating a very untidy situation. Thank you, Chair.
Thank you. Members. Yes, Honorable Paya.
Honorable Speaker, yes, I would like to invite the Honorable Wundo to start seeing this not from far but from near, because he says he's been seeing it from far. On the simple fact, the National Lands Commission has been unable to discharge its mandate because every time a judgment is made, people rush to court, they get garnishee orders, and all the money, even that which was meant for his constituency for payment, is taken away. So it becomes very impossible for the National Lands Commission to continue to work. And actually, some malicious individuals do that to disable the this National Lands Commission is not a darling of many people because it is trying to cure historical land injustices which have benefited many people for many years. And therefore, Honorable Speaker, for us to advance the spirit and letter of the Constitution on the issues of the National Land Commission, we have to ring-fence it against malicious individuals who just want to disable. Honorable Speaker, I know there are very many people who want the National Land Commission dead.
because they're the perpetrators of historical land injustices. So we have to insulate and give an opportunity for the National Lands Commission to advance the spirit and letter of this constitution by ring-fencing its money and avoid it from falling under Ganishi orders that justices all over the place want to throw and subvert justice for the local poor people for a long time. They have been looking for an opportunity to get justice. The poor people in his constituency, Honorable Oundos, will one day require justice and they will be saved by the National Lands Commission. So it requires all of us to handhold this National Lands Commission so that it has power not just to make decisions, but also to execute those decisions for the benefit of Kenyans. Honorable Speaker, I want to convince the Honorable Oundo.
No, the Honorable Oundo wasn't opposing anything.
No. He said that he wants to sing it from far. I want him to start singing it closer. And that is what I'm trying to do. So that he goes home convinced that we passed a good law. That is what I'm trying to do. I want to convince him that he goes home, sleep soundly, because we have passed a good law. Honorable Oundo, join us, those that believe in the National Lands Commission to cure historical injustices.
Thank you.
Honorable Speaker, Chair, allow me this. You know, the Honorable Nyamai chaired in the 12th Parliament, chaired the Committee on Lands. Right. And I was there with her. And I could see the pain that she went through, trying to bring justice to individuals, but she could not because this justice kept on being diverted by people who had a lot of interest. And this is the only opportunity to give the new chair of Land Commission, Land Committee in this Parliament, an opportunity to actually give justice to people. So, Honorable Oundo, kindly support this one. Kindly support this one.
The Honorable Oundo actually supported this, from what I heard, but Chair knows that the Court of Appeal in the last few days has overturned the High Court judgment of Oundo, and the court has declared that they cannot go ahead and do that. The jury is still out there. Honorable Mboko.
On this particular one, I think Honorable Baya is right, because it is so intentional that the ganchis that I spoke about appear when money is in the accounts of the Land Commission. And you would find that, like, even now as we speak, there's a great road in the northern corridor, which somewhat the money is just gansheed, and the people who are supposed to get those monies are unable to get. So this one will actually open space for even development to move faster, and at the same time, the people who need to benefit from those reimbursements to get their monies. Thank you.
Yeah, maybe the Honorable Baya should tell us how these guys who can get to know that there's money in those accounts. Be that as may, I now put the question that the new clause 2 be now read a second, the new clause 4 be now read a second time. Will as another opinion say aye? Will as another opinion say nay? The ayes have it. Remember, as I propose the question now, that the new clause 4 be part of the bill. I put the question that the new clause 4 be part of the bill. Will as another opinion say aye? Will as many opinion say nay? The ayes have it.
Title.
I put the question, members, that the title, that I propose the question that the title be part of the bill. I put the question that the title be part of the bill. I put the question that the title be the title of the bill. Will as another opinion say aye? Will as many opinion say nay? The ayes have it.
Clause 1.
I propose the question that clause 1 be part of the bill. I put the question that clause 1 be part of the bill. Will that opinion say aye? Will that opinion say nay? Ayes have it. Chairperson of Lands Committee, it's your chance to move this for reporting. The mover is Baya or the Honorable Chair? The Honorable Baya, I think it's your chance, actually. Who is the mover of this bill? You or Honorable Chair? Okay, Chair, go ahead.
Honorable Chairperson, I beg to move that the committee to report to the House its consideration of the National Land Commission Amendment Bill, National Assembly Bill number 43 of 2023, and its approval thereof with or without amendments.
To the House is consideration of the National Land Commission Amendment Bill, Bill number 43 of 2023, and its approval thereof with amendments. As many opinion say aye. As many opinion say nay. The ayes have it. So we'll pen the reporting so that we consider the next bill. The next bill is
the County Licensing Uniform Procedure Bill, Senate Bill number 9 of 2022.
Then Babaya.
Honorable Speaker, because this is a bill that emanates from the Senate, and considering that there are certain things that we may not or may agree with the Senate, we, in consultation with the Senate, Honorable Speaker, Chair, we request that we stand down this bill and put it at any other time next week, so that we are able to conclude certain matters on this bill before we take it through the Committee of the Whole. I beg to indulge you, Honorable Speaker. Thank you.
Thank you, members. The County Licensing Uniform Procedure Bill, Senate Bill number 9 of 2022, is therefore pended until the next time it's put on the other paper for the Committee of the Whole House. Next bill. This is the consideration of the second Senate amendments to the Water Amendment Bill, Bill number 33 of 2023. The Honorable Mudama, I'm told you're holding brief for the chair. Would I request that you sit where I can see you? Are you ready? Okay.
Clause 2.
Oh, members, I propose a question that the Senate amendments to Clause 2 of the bill be now approved. Chair, go ahead. Explain to us what this is about.
Chair, when the committee met and we look at what the Senate was bringing on board, they were trying to bring in some definitions like water service provider, contracting authority, and the county agencies, among others, which when we looked at it, Chair, we discovered that it will bring a different interpretation to what is contained in Water Act 2016. So, Chair, as a committee, we rejected it.
Thank you. Members, I now put the question that the Senate amendments to Clause 2 be now approved. As one other opinion say aye. As many opinion say nay. Nay. The nays have it.
Clause 3.
I propose the question that Senate amendments to Clause 3 be now approved. Chair?
Chair, Clause 3, I move that Clause 3 be rejected, institutional framework for carrying out and approval of the feasibility studies which determines the viability of any project in Kenya. And for that, Chair, we, as a committee, we rejected it.
Thank you. Members, I now put the question that the Senate amendments to Clause 3 be now approved. Will as another opinion say aye? Will as another opinion say nay?
Nay.
The nays have it.
Senate amendments to clause 4.
Chair.
Thank you, Chair. I move that clause 4 be rejected. And Chair, the reason being, there is already an elaborate legal and institutional framework in place, both under the PPP Act and the Water Act 2016 in the Cap 372, which ensures that there is financial integrity of all the PPP projects carried out in Kenya, which also safeguards the customer interest and guarantees equity access to water and sanitation of services of the fair price. And this further to the National Public Water Works should not be transferred to the county government as the Senate had intended. Thank you, Chair.
Thank you. I now propose the question that Senate amendments to clause 4 be now approved. I put the question that the Senate amendments to clause 4 be now approved. As another opinion say aye. As another opinion say nay.
Nay.
The nays have it.
Senate amendments to clause 5.
Chair.
Chair, I move that clause 5 be rejected, because as a committee we looked at it and we discovered that the section 72 of Water Act, Cap 372, empowers the regulatory bodies to publish the regulatory standards without approval of the cabinet. And for consistency, in this case, in the provisions of the law of the Senate amendment is welcomed. However, there is a need for further amendment to remove the requirement for publication in the Gazette, as these are the only standards and the standard guidelines and not regulation.
Thank you. I propose the question that the Senate amendments to clause 5 be now approved. I put the question that the Senate amendments to clause 5 be now approved. As another opinion say aye. As another opinion say nay.
Nay.
The nays have it.
Senate amendments to clause 6.
Chair.
Thank you, Chair. I move that clause 6 be rejected, giving a reason that the Act provides that handover agreements for completed waterworks shall be between the waterworks development agencies, for example, the Coast Water or any other agencies, and the county government. County government, the joint committee, or the authority of the county government, within whose area of waterworks is located jointly with the water service provider. The bill also seeks to omit the reference to joint committees and authorities in the process. Hence, the roles of the committee in the process has not been defined. Thank you, Chair.
Okay, I propose the question that the Senate amendments to clause 6 be now approved. Yes, go ahead. Where's the mic?
Thank you, Chair. I would like to support the rejection by the committee because looking at this, Honorable Chair, it is not in good faith and it is introducing a committee that is not clearly defined. So I support the Chair.
Okay, and I'll put the question that the Senate amendments to clause 6 be now approved. As many other opinions say aye, as many opinions say nay. The nays have it.
Senate amendments to clause 7.
Chair. The mic is on.
Chair, I move that clause 7 be rejected. Reason being that the bill proposes amendment to Section 72 of Water Act by introducing a new mandate for the Water Services Regulatory Body, that is WASREP, to evaluate and to approve water water, sewerage, and bulk water tariffs for the domestic and commercial and irrigation purposes. The regulator evaluates the tariff and approves the impositions of the tariff in line with the customer protection standard. Thank you, Chair.
Thank you. I propose the question. The Senate amendments to clause 7 be now approved. I put the question that the Senate amendments to clause 7 be now approved. As many other opinions say aye, as many a contrary opinion say nay. The nays have it.
Senate amendments to clause 9.
Chair.
Chair, I move that the clause 9 be approved. And when we looked at this, Chair, we discovered that what the Senate was recommending is in line with what is in Water Act 2016, is again in line with the PPP, which was enacted in 2021. So we supported as a committee.
Thank you. I propose the question that Senate amendments to clause 9 be now approved. I put the question that the Senate amendment to clause 9 be now approved. As many other opinions say aye, as many other opinions say nay. The ayes have it.
Senate amendments to clause 10.
Chair.
Thank you, Chair. I move that the clause 9 be
10.
rejected.
Clause 10.
Clause 10, sorry, be rejected. Reason being, again, sorry, Chair, I move that clause 9, clause 10 be accepted, because that is what we looked at it as a committee. And I would like to give the stand of the committee is that clause 10 of the bill seeks to amend section 100 of the Water Act, which deals with the supply of bulk water. The bill proposes that the bulk water supply services to the water services provider in the county or multiple county different from where the bulk water abstraction is situated shall be undertaken by the waterworks development agencies established under the section 65 of the Water Act. The proposed amendment of the bill by the Senate, which has provided and defined bulk water services provider, it follows therefore that the bulk water supply shall be undertaken by a bulk water supplier, and the definition has expanded to include the counties. Thank you, Chair.
Thank you. I propose the question that the Senate amendments to clause 10 be now approved. I now put the question that the Senate amendment to clause 10 be now approved. As one other opinion say aye.
Aye.
As many other opinions say nay. The ayes have it.
Senate amendments to clause 11.
Chair.
Chair, I move that clause 11 be rejected. Reason being that the clause 11 of the bill proposes an amendment to section 114 of the Water Act to expand the mandate of the Water Sector Trust Fund by broadening the scope of entities to which the fund caters. Currently, the Act mandates the fund to provide financial support to counties in provision of the water and sanitation services, and to assist in the financing of the development and the management of water services in marginalized and underserved areas.
Thank you. I propose a question that Senate amendment to clause 11 be approved. I now put the question that Senate amendment to clause 11 be now approved. As one other opinion say aye. As many other opinions say nay.
Nay.
The nays have it.
Senate amendments to clause 12.
Thank you, Chair. I move that clause 12 be rejected. Clause 12 of the bill seeks to amend section 119 of Water Act, which establishes the Water Tribunal. The Act established the tribunal but did not provide for composition of the tribunal members. The proposed amendment to section therefore seeks to cure this gap of the law. The Senate proposed that the 2 persons appointed under the Category C be nominated by the county, by the Council of Governors. The tribunal sets up under the Act was the tribunal set up under the Act was established to hear the dispute relating to implementation of the Act. As an arbiter, it would be prudent that the membership of the tribunal be as neutral as possible to avoid conflict of interest in the arbitration processes. Thank you, Chair.
Thank you. I propose a question that the Senate amendment to clause 12 be now approved. And I put the question that Senate amendments to clause 12 be now approved. As another opinion say aye. As many opinion say nay.
Nay.
The ayes have it. So members may now call the mover to move for reporting.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Senate amendments to the Water Amendment Bill, National Assembly Bill number 33 of 2023, and its approval thereof. I have to say with amendments, with amendment.
Thank you. I now put the question, members, which is that the committee do report to the House its consideration of the Senate amendment to the Water Amendment Bill, National Assembly Bill number 33 of 2023, and its approval thereof with amendments. As many other opinions say aye. As many opinions say nay. The ayes have it. Give me the 2 reporting documents. There's supposed to be 2. One for land. One for land and one for the other one. Is there one for land?
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the House do agree with the committee on the said report. I also request Honorable Jerusha Mumanyi to second the motion of agreement of the report of the Committee of the Whole House.
Honorable Speaker, I want to second the report from the whole House.
Very well. I now propose the question, which is that the House do agree with the committee in the said report.
Put the question. Put the question.
Very well. I'll defer the putting of the question to this particular bill until the next sitting. Next order. Very well. We go to the next bill. Chairperson, to report on the Senate amendment to the Water Amendment Bill, National Assembly Bill number 33 of 2023.
The Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Senate amendments to the Water Amendment Bill, National Assembly Bill number 33 of 2023, and approved the same with amendments.
Mover.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also request the Honorable Muthama to second the motion for agreement with the report of the Committee of the Whole House.
Proceed, Honorable, and give him the microphone.
Honorable Speaker, I stand to second the motion.
Very well, honorable members. I propose the question, which is that the House do agree with the committee in the said report. I think I also further order that the putting of the question to this particular report be deferred to the next sitting. Next order.
Order number 13, the Statute Law Miscellaneous Amendments Bill, National Assembly Bill number 67 of 2023, second reading.
Leader of Majority Party.
Thank you. Give me the mic. Okay. Honorable Speaker, I want to thank you for giving me the opportunity to move the Statute Amendment Bill. If you allow me, I reorganize myself a little bit. Oh, yes. Thank you very much, Honorable Speaker. Honorable Speaker, I beg to move that the Statute Law Miscellaneous Amendment Bill 2023, National Assembly Bill number 267 of 2023, be read for the second time. Honorable Speaker, the bill is introduced in keeping with the practice of making various amendments that do not merit the publication of separate bills and consolidating them into one bill. Of course, Honorable Speaker, when I was a member of Parliament in the 12th Parliament, I used to have a problem with this kind of omnibus bill. But now I realize it is very important that we do this because we can publish as a miscellaneous of what is called the omnibus bill. You know, Saul also became Paul. Honorable Speaker, the bill contains proposed amendments to 9 statutes. 9 statutes. So, Honorable Speaker, in this bill, we have 9 statutes that are being amended. And these statutes include the Children's Act, Honorable Speaker, the Copyright Act, number 12 of 2001, the Scrap Metal Act 2015, number 1 of 2015, the National Employment Authority Act 2016, number 3 of 2016, the Fisheries Management and Development Act 2016, number 35 of 2016, the Energy Act 2019, number 1 of 2019, the Public-Private Partnership Act number 2021, number 14 of 2021, the Parliamentary Services Act 2019, number 22 of 2019, and the Judicial Service Act 2011, number 1 of 2011, which is sponsored by the leaders of the majority party. Honorable Speaker, delving into the several acts that are here, I would like to start with the Children's Act 2022. And I thought the Honorable Millie Odhiambo would be here because this is her forte, Children's Act. That this act, Honorable Speaker, is here because of a court case. That is the Children's Act with the findings of the court in adoption case number E004 of 2022, where the court held that the provision of section 186(4) of the Children's Act of 2022 goes against the tenets of the Constitution, which forbids discrimination on any ground. That section discriminates against a sole male applicant for adoption. Honorable Speaker, the gist of this amendment is that the court cannot just go to an adoption center and adopt a child. But then people went to court and say, yes, a man should adopt a child, and therefore sought an interpretation of the Constitution. And the court actually said there is discrimination when you discriminate that it is only women who can adopt children and not men. And therefore, we have to align this to the Constitution and therefore take cognizance of the fact that it's because of a court ruling, and therefore this is, that the committee also observed that there's a need to amend the bill to make reference to the correct section being amended, which is section 186(6)(e), not 6F of the Act, which prohibits the court from granting a sole male applicant to adopt a child. That is the first act, Honorable Speaker. The second act that is coming out for amendment, Honorable Speaker, is the Copyright Act, number 12 of 2001. In this act, Honorable Speaker, it seeks to provide for equitable remuneration of performers and producers of sound recordings and expand the responsibility of collective management organizations towards authors and performers. Honorable Speaker, you've had a lot of our musicians, a lot of our producers, those that are on TikTok, those that are, you know, all those people. that you see there hasn't been fair remuneration and all that. So this bill, the Copyright Act number 12, is coming to make certain amendments and certain provisions that will rectify. Honorable Speaker, the committee recommends that the proposed amendments to the Copyright Act 130 be withdrawn from the bill for the following reasons. But I wouldn't want to go to those reasons as it is now, but we have an opportunity to look at this bill, Honorable Speaker, and make the various amendments. Honorable Speaker, following on the heels of that is the Scrap Metal Act 2015. The amendments to the Scrap Metal Act 2015 to, among other things, provide for the issuance of licenses to persons dealing with copper, aluminum, and other alloys, and to increase penalties for offenses under this act. Honorable Speaker, if you live in those urban areas, there are many times when you have a water meter, that water meter is stolen because people want to sell it as scrap metal. If you put your car out there, somebody comes and takes the bumper and sells it as scrap metal. Even transformers, they want to remove the wires and get the copper out of it and sell. They have even been taking away gates of people so that they can go and sell as scrap metal. This amendment, Honorable Speaker, seeks to rein on such people. And what it needs to do is actually to bring licensing. If you want to be a scrap metal dealer, you must have a license. And also to increase penalties for people who are in situations where they get caught in this vandalism that they have. So that is the third act, Honorable Speaker. The fourth act, Honorable Speaker, is the National Employment Authority Act 2016, number 3 of 2016. The amendment of the National Employment Authority Act 20 provides that the act shall apply to an employer who employs more than 10 employees. If you have more than 10 employees, then you are subjected to the National Employment Authority Act, Honorable Speaker. That is the amendment that we seek to bring on this. Honorable Speaker, the next is the Fisheries Management Act. In this Fisheries Management and Development Act 2016, or number 35 of 2016, proposes to amend the Fisheries Management Act 2016 to provide that the Cabinet Secretary responsible for matters relating to fisheries will be the chairperson of the Kenya Fisheries Advisory Council. In the past, there has been duplication of roles where you have the Cabinet Secretary, but the Advisory Council is chaired by someone else. Then you ask yourself, who is it advising? You know, and therefore, we propose that the amendments that we're bringing is to have the Cabinet Secretary be the one that chairs the Advisory Council. Just like the President chairs his Advisory Councils, even here we have an opportunity to have the Cabinet Secretary. So this covers the governance challenges posed by the current position on appointment of the chairperson, noting that the council mainly composed of Cabinet Secretaries. You cannot have a council that is of Cabinet Secretaries and a Council of Advisors that is Cabinet Secretary, then it is chaired by someone else who is not a Cabinet Secretary. So we want to cure that, Honorable Speaker. Second, on the heels of that, Honorable Speaker, is the Energy Act 2019, number 1 of 2019. Honorable Speaker, this bill proposes to give effect to the recommendations of the Presidential Task Force on the review of power purchase agreements. You remember we have had a lot of discussion in this parliament that we must review power purchase agreements. We must review power purchase agreements because, so the president set a task force and the task force made certain recommendations, and those recommendations now need to be incorporated into the act so that they can have a force of law, so that we can have a better regulation, a better regime in terms of power purchase agreements, Honorable Speaker. Honorable Speaker, we have the Public-Private Partnerships Act 2011. Now, this bill, Honorable Speaker, proposes to amend the Public-Private Partnerships Act of 2021 to correct typographical issues of typography. Yes. No. Typographical and cross-referencing errors contained in the bill.
Order, Honorable Bayer. You know, once a member rises on a point of order, we have to hear him. What's your point of order?
Yeah, thank you, Mr. Speaker. Mr. Speaker, I want to know whether it's in order, Mr. Speaker, for a very important motion like this, for this Parliament to pass any important motion like this without a quorum in this House, Mr. Speaker.
So you are rising on which point of order? Standing order. But anyway, whichever way he has raised a question on quorum, And our standing orders are very explicit on quorum, and therefore give me the very well. A member has risen from his place, and he has raised the issue of quorum, that is outstanding order number 35, and therefore I can ascertain that there's no quorum in the House and ask the sergeant to ring the bell for 10 minutes. Proceed, sergeants.
Well, the House lacks the requisite number of members for the House to proceed with its business, and this is pursuant to the House Standing Order number 35, that at any point after the chair has taken, this is 35.1, that indicates that if at any point the chair is taken or when the House is in committee, a member objects that there is not quorum present, the Speaker or the chairperson shall count the members in the House or the committee as the case may be. For now, it is the House, the proceedings of the House. Earlier on, it was the committee over the whole House stage. So in this case, we are talking about the House, the quorum of the House during the proceedings over the House business. And if on the count of order of count under paragraph 1, if the members present in the House are counted and the quorum does not appear to be present, then the Speaker shall cause the bell to be rung for 10 minutes. That is what is currently underway, a 10-minute quorum bell. This is, of course, to alert the members of the National Assembly who may be within the precincts of Parliament but not inside the chambers to make their way to the chambers, that their presence inside the chambers is highly required for the business to continue. But before the quorum bell or before that particular interruption on the lack of quorum inside the House, the business on the floor of the House was on the statute law, miscellaneous amendment bill. This is a bill originating from the National Assembly, a bill by the leader of the majority party. And it is a bill that is at its second reading stage. the deputy leader of the majority party, Honorable Owen Baya, was on the floor of the House presenting this particular bill, but because the House does not have the required number, and this is a bill that seeks to make various amendments to various statutes, including the Children's Act 2022, the Copyright Act 2001, Scrap Metal Act 2015, among other statutes. The member rose to alert the Speaker that these are very important statutes, and yet the House does not have the required number of members to be able to enable that particular business to continue. Let's take a look at what these statutes are. Is that the Children's Act 2022, this bill proposes to amend, this bill proposes to remove the provisions which prohibit the court from granting a sole male applicant adoption of a child. This is the Children's Act 2022, number 29 of 2022, a statute that this bill proposes amendments to, and that particular amendment is to remove the provisions which prohibit the court from granting a sole male applicant adoption of a child. The Copyright Act 2001, number 12 of 2001, the amendments that this bill proposes to bring to this particular act is to make provisions for the equitable remuneration of performers and producers of sound or producers sound recordings, and expand the responsibilities of collective management organizations towards the authors and performers. This is the Copyright Act 2001, number 12 of 2001, which is part of the statutes that the Statute Law Miscellaneous Amendment Bill 2023 seeks to bring forth. The amendments also to the Copyright Act is that it also proposes to bring collective management organizations under regulation by the board in order to enhance their efficiency. The Scrap Metal Act 2015, number 1 of 2015, also is part of the statutes that this bill proposes amendments to. Proposes amendments to, which include to provide for a special license for dealing in copper, aluminium, and their alloys. This is intended to protect critical infrastructure, for instance, transformers. The bill further proposes to restrict the disposal of scrap metal from critical infrastructure to 2 national entities, namely the Numerical Machining Complex and the Kenya Shipyard Limited. Just to let you know is that currently is a quorum bell underway. The House does not have, or it happens that the House does not have the required number of members inside the chambers during the proceedings of the House business. And that is what has necessitated that bell. It will be on for 10 minutes. If no quorum is present, at the expiration of the 10 minutes, and if the Speaker is in the chair, the Speaker shall adjourn the House until the next sitting without a question put. This is pursuant to the rules of the House. Order number 35 of the Standing Orders, which guides the House business. The Sergeant at Arms also trying to see whether the members will be walking in, or the division bell will, or the 10 minutes of the division bell will expire. and cause the Speaker to adjourn the House until the next sitting. We shall be waiting to see if the members will be coming to the chambers. Well, back to the business that was on the floor of the House before that particular interruption for the bell, with the House lacking the quorum to continue with its business this afternoon sitting, is that the Scrap Metal Act 2015 is part of the statutes. Under the Statute Law Miscellaneous Amendment Bill 2023, that there are various amendments that this bill seeks to make to, and the Scrap Metal Act is that the Ministry of Industrialization, Trade and Enterprise Development has also proposed the regulation of imports in addition to exports, as well as the enhancement of several penalties in the Act to deter vandalism and other prohibited acts. Well, the Speaker
Very well.
is addressing the House. Allow me to hand you over to the live broadcast.
A member rose from his place concerning order number 35 on the matter that concerns quorum of the House. And indeed, as attained, there was no quorum in the House. Honorable members, after ringing the bell for 10 minutes, I still ascertain there's no quorum in the House. And therefore, we may rise. And honorable members, and the time being 5:05 p.m., this House stands adjourned until Tuesday, 30th April 2024 at 2:30 p.m.